license.
Really?
Yep.
Okay, that's good.
So he'll be active with our company tomorrow. Jonathan Dunn. I don't think so. He was in his class.
You ready to go? We are live.
We're live?
Yeah.
Oh,
Yeah. Don't worry, we can cut off the
Okay.
Or we get it this. We got it going. Yes, sir.
sounds good.
All righty.
All right. You guys ready?
We're ready.
We'll get started. Well, welcome to tonight's class. Tonight we're going to be going over the Working with Real Estate Agents brochure and the new North Carolina Buyer Agency Agreement, how to explain it, and how to fill it out when you have a new buyer client. So first, we'll get into the Working with Real Estate Agents disclosure. Hopefully everybody on the camera can see it. But either way, this is in SkySlope and Zip Forms. It is a document that needs to be presented to every client, consumer that you come across. When you have a buyer, you're going to go over this with them, and this is not a contract. This is strictly just a disclosure to let the clients know that they have the right to be represented by an agent. And when they are signing it, there is three options. There is the buyer agency, which is what we're going to cover, which states that the agent has been hired to represent this client in the transaction of them purchasing real estate. There is dual agency. There is two types of dual agency. There's dual agency and designated dual agency. Dual agency is when the firm represents the buyer and the seller in same transaction. Now, remember, the firm holds all the clients, not the agent. So that's where dual agency can fall into play when anybody under the same firm represents the buyer and seller on the same transaction. Designated dual agency is when the client does not want the same person to represent the buyer and seller in the transaction, or any other agent in the firm that knows proprietary information about that client to also represent the other party. So designated dual agency, if that comes into play, the firm will appoint an agent to represent the other party if it's not already been determined, but neither person representing the buyer or seller in that transaction can know the proprietary information about the other party. That falls in under designated dual agency. And then the last on this form is unrepresented buyer. That would be, of course, exactly what it says. If there is a buyer that is buying a piece of property and they chose to be unrepresented. So this has to be presented and signed by your client at first substantial contact. If they choose not to sign it, which they have the right not to, then you just need to make note on here that consumer so-and-so chose not to sign it on this date, but it was presented. Now, as long as you have that, you are compliant with the commission. Any questions about this? No. All right. Now, the buyer agency agreement. This buyer agency agreement just came out in October. It is the new revised one. The previous one was almost twice as long. This one they have shortened. It is down to only 3 pages. So, yes, a lot less paper for us. But we're going to go over it paragraph by paragraph so you understand what it says and know how to fill it out when you have a buyer and you are presenting this to them. So this is the exclusive buyer agency agreement. Exclusive states that they are hiring you and only you to represent them in the transaction of them buying real estate. First section, this agreement is between buyer and firm. That's where buyer will put their information and we will put the firm's name. Because remember, the firm holds the client, not the agent. The agent is representing the client and is helping the client, but the firm is the one that holds the actual client. Next is services provided. This section is That firm will assist the buyer in purchasing real estate, and you will describe the area, the location, the description of possibly what they're looking for, whether it's Charlotte metro area. Are they looking in a specific area, a specific zip code, a town, a whole state? That's where you will put kind of what your criteria is to help them find the property that they're looking for. Now, next is buyer disclosures. There's 3 options, A, B, and C. The first one you have to check, has the buyer entered into another buyer agency agreement with another firm? Yes or no? We would hope no, but if they have, then you can still have this signed, but you will need to contact the other firm and make sure that you are able to help this buyer while they are under their contract, because we don't know what type of contract they have. If they have a non-exclusive buyer agency, then yes, we can help them. If they have an exclusive buyer agency, then we cannot help them until that contract terminates or they get out of that contract. We cannot advise them on how to get out of a contract because that would be speaking law, and we are not attorneys. Next is the buyer working with a relocation company? Yes or no? Why is that important? Because if a buyer is working with a relocation company, then the relocation company very well may be the buyer in this transaction. Everything may have to go through that relocation company, so that way we need to know so we can get in touch with them and see what they need, and are they going to be the quote-unquote client for this transaction. Letter C is, has the buyer received sample copies of the offer to purchase and professional services disclosure and election? Yes or no? If they have not received them, you have to check no, but you need to make it a point to, at some point in the immediate future, present them with sample copies of that. Because once you get ready to write an offer to purchase, it is also in there, have they received sample copies? So you want to go ahead and get those presented and get that out of the way. Terms of this agreement, number 3, that states when would this contract expire. So you will put a date in that line. You preferably want to put a hard date like March 1st, not 90 days from this, signing of this. It's much more clean if you put a firm date like March 1st, and make sure you have the month, the date, and the year. Because this states that this will expire at 11:59 p.m. on said date. Next is fees for services. There's 4 types of fees that we can accept from a buyer. A non-refundable retainer fee, a percentage of the gross sales price, a flat fee, or a other amount. Now, what are the differences? A retainer fee would be something if you are charging an upfront fee that you will get to keep whether that client buys a house or not. That would be up to you if you want to do that. There are very few. In fact, I don't even know of an agent that charges a retainer fee. So if you were to charge one, be expected that a buyer may try to refute it because they could go find 100 other agents that do not charge a retainer fee. So just keep that in mind. Next, which is the most common, would be a percentage of the gross sales price. So you would put in that percentage. Is it 3%, 2%? What are you agreeing with that buyer that you charge for your fees and services? Next is a flat fee. Are you charging a flat fee? Flat fee would be an even $5,000. Are you charging your buyer an even $5,000 to help them in this transaction? If so, that's where you would put that. Last is other specific amount. Is there any other amount? Now that can be where you can add, if builders were offering bonuses, you could have, you are charging a 3%, 3% of the gross sales price, and then under other specific, you could put a $5,000 builder bonus if a builder is offering a bonus. So that is a way you can now make sure you can include both of those on this buyer agency. If there was some other type of compensation that you were receiving from your buyer, example, a new car, that would be considered compensation. Anything of value, you would put that in there. I don't know of any people offering new cars to help them buy a house, but if it were offered, that would be something that could go in there. Next, fee earned, due, and payable. So when is the fee earned, due, and then payable? It is earned when you, as the agent, have got your buyer into a contract with the terms that they have agreed upon in here and the location that they have asked for. Once you have that contract and it is signed by all parties, your fee is now technically earned. Now, when is it due and payable? It is due and payable when the buyer closes on the property or if the buyer breaches the contract. If the buyer defaults on the contract, in theory, you are still owed your commission because you did your job to get it there and they faulted. But 99% of the time, it will always be paid when you close on the property. Next, seller and listing firm assistance. This states that a firm may seek compensation from the seller or the listing firm. Now, buyer needs to understand that sellers and listing firms hold no obligation to pay a buyer's agent's commission, but we as buyer's agents will try our best to get all or portion of our fee from the seller or listing agent. And if we do, then the buyer may only be responsible for that difference if the seller or listing firm is not offering the full amount that we charge for our services. So we let the buyers know that we will do our best to get what we can from the seller, but again, they hold no obligation to pay our commission. But if they are paying it or we can negotiate it, we will collect it so the buyer may not have to pay that or at least not pay all of it. Next is mutual termination required. That states that this is a two-party contract. One party cannot terminate it. It takes both parties to sign to terminate this contract. So buyer cannot just come one day and say, I'm done, I terminate this contract. They cannot do that. You also, as the agent representing the company, and the company said the firm agrees to terminate this contract. So both parties have to agree to terminate before it can be officially terminated. Next is protection period. There's a blank there. Protection period states that if a buyer were to enter into a contract that is of a property that you introduced to them or you showed them, and they go into that contract after this contract expires within blank number of days. So if you put 45 days after this expires, if that buyer goes under contract with a property that you showed them or introduced them to, you are now the procuring cause and you are still owed that commission. The only time that does not come into play is once this expires, if that buyer signs a buyer agency with another firm and then goes under contract with that property. Then that nullifies this paragraph because they are now represented by another firm. We hold no bearing on that. But if they were to do it without another firm, that paragraph is there to protect you as the buyer's agent, to hopefully deter a buyer from using your services, find a property, get all the information on it, then let this terminate and then try to buy it and undercut you. So make sure you put a number in there. Usually myself, I put either 45 or 60 days. So, but whatever you chose to put is totally up to you. Next is negotiable fee and additional compensation. Now, in big bold letters, it states that buyer understands that the commission is always negotiable. It is not set by the state or the realtor association or our board. Now, as an agent, you can set your commission for what you charge for your services. The firm can let you know what we charge, but it is always negotiable. But you always have the right to say, this is what I charge for my fees and services. Next part of that is additional compensation. If there is any additional compensation that is offered to you as the buyer agent, and it is not spelled out in section number 4 about fees for your services, you cannot accept that additional compensation unless the buyer agrees to redo this contract and spell out that additional compensation. So if you are offered additional compensation that is not in here and you want to accept it, you need to disclose to your buyer that additional compensation is being offered. In order for you to receive it, you and your buyer need to redo this contract, amend it, and change and add in there that additional compensation. Now it is legal for you to accept. What would be an example of that? If you put 2.5% as to what you're charging, and the listing agent comes and says, we're offering 3% if you have a buyer. Well, you would love to get that 3%. You deserve that 3%. At that point, you wish you would have wrote 3% in there. So, but if you go back to your buyer and adjust it and change it to 3%, now you can accept that 3%. Any questions so far?
So if you have to adjust it, do you have to rewrite the whole buyer's agreement, or can you just cross it out and initial it?
So question is, do you have to rewrite the whole contract, or can you cross it out and initial it? You can do either.
Okay.
If you change something, you can cross it out and rewrite something, and then you and the client both initial next to that change. Now that change is legal and enforceable. Now, if you were to have 2 or 3 changes, I would recommend just redoing it. But if you have just one change, it is very, very practical just to cross it out and then have everybody initial next to the change. And add the date.
Very good.
Yes.
I have another question. So the relocation company, if you are working with a relocation company, they're the one that are going to be buying the house, or is it going to be the client buying the house?
All right. Question is, if you're working with a relocation company, is the relocation company going to be the one buying the house, or is the client buying the house? Most of the times, the relocation company will be the client because they are the ones that have been hired to move an employee from one location to another. The company, quote unquote, that the relocation company is working for is paying to assist an employee from moving. So they would be, in essence, one of the clients or the client in this transaction. Now, how do you verify that? You would need to get in touch with the relocation company and find out what their policy is on the situation, because there could be different policies on different relocation companies. Some relocation companies may have the client as the client, and the relocation company just has to be kept abreast of all the things going on in the transaction. Some may want both as the client, the person and the relocation company. Some may just want the relocation company.
So the signatures depends on what the relocation, how they work it?
The signatures will depend on how the relocation company works.
Okay,
Correct.
I have another.
All right, another question. Yes.
Is this the same agreement as I could use for commercial property, or is there a different agreement?
So question is this the same for commercial and residential? There is a different one for commercial.
Okay.
This one is for residential.
Okay,
Correct.
thank you. That's it.
All right, you're welcome.
Sorry.
And then at the bottom, agent and buyer need to initial. All right, page 2. Top of page 2 goes into dual agency. Now, we just talked about dual agency, but we're going to get into it a little bit deeper. Dual agency is when the firm represents the buyer and the seller in a transaction. If a firm represents a buyer and a seller in a transaction, buyers need to understand, and it's written in here, that proprietary information could be disclosed to the agent that could hinder the buyer's negotiating power, because buyer agents of also representing the seller know means of both parties. So they can't disclose everything to both parties because they have to keep some of that confidential. But because they know things, buyer needs to understand that it is possible that their negotiating power could be hindered if they have dual agency. Now, with dual agency, does that buyer accept and acknowledge they will allow dual agency, or are they going to want exclusive representation, which is no dual agency, or are they going to want designated dual agency? So they have to initial which ones they authorize. If they authorize dual agency, they authorize that firm can represent buyer and seller. If then there's another line, do they authorize this individual agent to represent the buyer and seller, the agent that is working on this buyer agency with them? If they don't want their agent that's representing them to also represent the seller, but are okay with dual agency, then they will check that they will want to practice designated dual agency. And when that is checked, we will have to make sure whoever the agent is representing the other party does not know any information about this party. If there is 3 agents in the firm that have met this buyer and have talked with this buyer, neither of those agents can participate in designated dual agency because they have met the buyer, they know the buyer, and they could know proprietary information about that buyer. So we would have to find someone other than them in the firm to represent designated dual agency. Dual agency also can be advantageous to a buyer and seller. And this isn't written out in here, but I like to just acknowledge that because the reason it can be beneficial to you, to the firm, to the buyer, and the seller is there is a large number of transactions that may fall apart due to the agent. The agent may get too personally involved. The agent may not be doing their job. So if we represent dual agency, we can also help control the agents that are operating in this transaction and oversee it and make sure those types of things hopefully do not happen. So that's something just we want to keep in our minds, that that is a reason it could be very beneficial for us and the clients with dual agency, since as we know, all of our agents at our firm are the best and we always do great with our clients. All right, material facts. Regardless of whether an agent is participating in dual agency, all material facts must be disclosed to all parties. That is no exception, period. There is no reason any material fact can be withheld from anybody. They always have to be disclosed. You as an agent are held to a higher standard. And if you know a material fact, you need to disclose it to all parties. Next is waiver. Should firm become a dual agent, buyer waives all claims, damages, losses, expenses, and liabilities from the agent, except violations from the Board of Realtors and the license law and ethics. So if there is anything that might be disclosed or something like that, that buyer acknowledges that they waive all of that to the agent unless they violate license, law, or ethics. Surveillance. Next section is number 7, surveillance, photographs, and video. This is always a big one. You always want to let your buyers know that in today's world, you can walk into a house and you could be under video surveillance. Now, it is illegal for a seller to have the audio on when we are viewing a home. Does that mean that all sellers turn off the audio? No. So be aware of that it is very possible they could be listening, but they are more than likely at least watching. So let your buyer be aware that we could be under video surveillance when we are on someone else's property. Now, buyers may also take videos and pictures of the house that they are touring, as long as they are only going to use those videos and pictures for their own reference, and they do not take pictures or videos of anything that could be construed as violating an owner's privacy. An example of that is buyer cannot open up their medicine cabinet and take a picture in there, or videotape inside their nightstand. Anything that is in open and plain sight, they can take a picture of if they need to use it for their own reference when they're considering purchasing the home, but only for that. Also, buyer needs to be made aware that firm cannot, neither can buyer, cannot take possession of the photos of that listing when they close on the house. When they close on the house, those photos will still be on the internet. Those photos cannot be transferred the rights to the buyer, and the buyer needs to understand that when they purchase that home, it is possible that those photos of the house they purchased will still be up and on the internet forever. As we all know, once it's on the internet, it's out there. So just, again, want to let buyers know when they purchase a home that it is very possible that the listing photos from that listing could be on the internet and available for the public even after they close on the house. Next is other professional advice. Other professional advice. We as realtors recommend that our buyers seek other professional advice while considering or under contract to buy a home. What would be considered other professional advice? A home inspector, an appraiser, a closing attorney, a contractor. We will gladly recommend those. But buyer understands and needs to be made aware that we cannot be held liable if they do not do their job or they do something they're not supposed to. We only recommended it. So we will try our best to only recommend reliable people that we have used in the past. But if that person or company does not hold up their end of the deal or does not do something that the buyer is very upset with, the buyer understands that they hold us harmless of that. Next is inspection costs. Buyers need to be made aware before going under contract that any inspections, unless previously agreed upon, will be paid for by the buyer. What are the inspections? The appraisal, a home inspection, wood destroying insect inspection, an HVAC inspection, anything like that. Any of those, buyer is going to be paying for out of their own pocket unless it is previously agreed upon and signed off on. And then at the bottom of page 2, agent and buyer initial. Now let's go to the last page, page 3, confidentiality. Confidentiality states that firm will not disclose any confidential information to another party unless written permission is given by the buyer. Now that, again, from the previous page, that does not mean material facts. If there is material facts, those have to be disclosed, even if the buyer thinks they are personal confidential information. What's an example of something a buyer might think is personal and confidential that is a material fact? Is if the buyer gets notification that their loan has now been denied. That is a material fact that needs to be disclosed to the seller. That buyer can no longer achieve financing. Buyer may think that is private information. It can be construed as private, but it is also material fact, so it has to be disclosed. Any other confidential information that is not a material fact, buyer understands that the firm or agent will not disclose that without written permission. Big red letters, section number 11, wire fraud warning. Let buyer know. That is big in today's world. There is wire fraud everywhere. Do not wire money to anybody without explicit written confirmation from your agent, the firm, closing attorney, and lender. As for a buyer, the only time they may need to wire money would be if they need to wire their funds prior to closing. And we will confirm that with the lender, the attorney, and our buyer and make sure everybody is on the same page. Other than that, there is very rarely any situation where a buyer will have to wire money to anybody. So let your buyer know if they get an email or a request to wire money to contact you immediately, and do not do that. Okay? Big one. Number 12, additional terms. This is where you would put any additional terms if you had them. If there were any additional terms that you wanted to make part of this contract with your buyer, or if the buyer wanted to make any additional terms in this contract. These are the lines where you would write that. What would be some examples of that? A great example would be you could put in here, you as buyer, if you are ever dissatisfied with my service, you may cancel this agreement upon any time with written request. So if you have a new buyer client that is a little apprehensive about signing a 6-month buyer agency with you, and they would like a quote unquote probationary period, you could put something like that in here to give them some ease. If the buyer had already made an offer on another property and it never got accepted, and the buyer said, I would love for you to help me, but if that seller were to contact me back and accept my offer, I would not owe you a commission since I've already pursued that as the buyer. That is another example of something that might be added into additional terms. If your buyer has additional terms that they would like to add into the contract and you are unsure about it, please contact myself or your manager and we will discuss it. Other than that, if there is nothing, make sure you put NA or none. You do not want to leave anything blank in a contract. And that's not just this contract. Any contract that has lines where you fill something in, if there's nothing to put in there, put NA or none. Next is merger, modification, assignment, enforcement, attorney fees, and governing law. So this states that there can be no modification, no assignment, no merger, or any type of this contract within the parties or to another party without all parties of this contract agreeing and signing off on it. It's pretty self-explanatory in the most part, but nothing can change, nothing can be added, nothing can be sold, nothing can be transferred from this contract to another party or from a party without all parties of this contract signing off on it. Last, non-discrimination. We as agents cannot discriminate against anybody for any protected class. Last is the buyer's signature. They will fill in their name, their signature, their date, their contact phone number and email, and mailing address. This needs to be filled out by all buyers. So if you are working with a couple, they both have to fill this out. If you're working with two partners, they would both fill this out. And then at the bottom, there is firm, which would be our firm's information, your information as the agent, and then your signature, the office address, your contact phone number and email, and then again at the bottom, buyer and agents, all initial the bottom of page 3. So that is our new buyer agency form. Does anybody have any questions about the buyer agency form or the working with real estate agents disclosure? Nope. All right. Well, I want to thank you guys for being here. I want to thank you for listening. I hope this was very beneficial and you learned something. But yeah, feel free to let me know your thoughts. And thank you guys for joining, and thank you. And I hope you enjoy this video and it helps you in your real estate career. Thank you, everybody, and have a great night.